Today, Tuesday, the Supreme Court is hearing oral arguments in a major case. It's called Gonzalez v. Gonzalez, and at stake is Section 230 itself. You've probably heard a lot about Section 230 in recent years. It basically shields internet companies from liability for harmful content that gets posted on their platform. Now, here's the Washington Post's quick summary of the case. Quote, in November 2015, 3 rifle-wielding ISIS gunmen opened fire at a restaurant in Paris, killing 23-year-old Nohemi Gonzalez, a college exchange student. Almost 8 years later, her family is seeking justice for her death, targeting not the gunmen, but the tech giant YouTube in a landmark case that could shift the foundations of internet law. Now, Krystal, there is something important about Section 230, I think, to recognize, which is that a lot of these big tech giants at this point, Facebook, for instance, has been running ads like in Axios for a year saying, we're okay with Section 230 reform because they now know that they have the financial resources to kind of handle it. They've had a long time to figure out where to go with it. There's no question it would hurt them. But they're also sort of prepared for what might happen with Section 230. Now, any regulatory changes happening through a court decision, on the other hand, there's nothing they can do to lobby the Supreme Court. There's really nothing that they can do to predict what might come out of this case, what might come out of the arguments. The arguments today should give us some indication of how this case will unfold. Obviously, it's a pretty business-friendly Supreme Court, so Google has that going for it.
Right.
But Section 230, Clarence Thomas has come out against basically Section 230. He said that maybe we should have a different approach. We should maybe be treating them like common carriers, these tech giants like common carriers. Google, Facebook, Twitter, they want in general to not be considered publishers, even though they do all kinds of publishing, whether it's on the search engine itself, whether it's through YouTube. What they're doing fundamentally is publishing, and Section 230 allows them to do that without the liabilities that news outlets have when they publish harmful information. This is a fascinating case because we're talking about life and death.
Right. Well, it's also one of these weird, interesting horseshoe issues because there's a critique of Section 230 from the right, and there's a critique of Section 230 from the left. Oftentimes the right focuses on, and I think these concerns, by the way, are justified, on the ability of platforms like YouTube or Twitter or Facebook or Google to discriminate against creators and against content based on political ideology. I mean, the reality is they have carte blanche to do whatever they want with their recommendation algorithms. And so the critique from a lot of liberals and Democrats is that they aren't doing enough to combat harmful content, misinformation, et cetera, et cetera. And so the context here in terms of when this little provision was originally enacted, this was in the early days of the internet. It was kind of before these companies had become gigantic monopolies. It was before recommendation algorithms began to drive literally everything in terms of content distribution on the web.
Really before social media, too.
Correct. So this was really more, they were thinking about these message boards, for those of you who are old like me, like this where you just post and it's there, and somebody else posts and it's there. And so they really were aimed more at a concern that if these companies had total liability as publishers placed on their heads, then it would stifle innovation. And I think those concerns, by the way, were justified. And in the wake of this provision being enacted, there was, in fact, an explosion of innovation. But it also then enabled the giant monopolization of the entire tech sector space. And so now you have critics of Section 230 from both the left and the right who are saying this should not have been interpreted as carte blanche. You can do whatever you want. You can manipulate this algorithm however you want and serve up whatever content you want and push whatever content you want without having any sort of responsibility as a publisher. So the question I think that's in front of the Supreme Court, as I understand it, is are there any limiting principles here? And basically what some people who have been thinking about this and proposing reforms, one direction you could go is, okay, there's still an opportunity to be held harmless of the type of content that's posted on your platform. I think that, under certain circumstances, that makes a lot of sense. But you have to meet certain guidelines. You have to be regular. You have to meet certain standards that we want in terms of having a neutral platform that serves as really kind of the, a public utility at this point,
right,
in terms of how we communicate with one another. So that's what's at stake here. I have no idea what this court is going to ultimately find, if they, curtail this at all, if they send it back to Congress. I really don't know what direction this will ultimately go in, but the implications of it could be hugely profound.
Yes, and I'm glad this is going to be, I mean, it's actually hard to overstate how important this is, the oral arguments today, because we're really going to get a glimpse into how justices are grappling with these huge questions. And one thing that our government has struggled with in the past, understandably so, is that new technologies for older generations, it's harder to sort of be in full contact with and understand exactly how profoundly they have changed human existence, if they're not as central to your own existence because you grew up without them and you don't sort of have the level of tech fluency. So I'm really curious about that. But on the other hand, this is fundamentally about publishing, and that the insight into how the court is thinking about publishing. Clarence Thomas in particular, not the most vocal questioner, but someone who has said, the public utility point that you made, the common carrier framework, treating these companies more like phone companies than their own little independent businesses, is probably the best way to go. So I would expect to hear that argument fleshed out from who I considered one of the most important legal thinkers. I mean, whether or not you agree with him, he definitely is. So this is a huge day. This is really big implications, and this is more from the Washington Post. They say the Gonzalez family's lawyers say that applying Section 230 to algorithmic recommendations incentivizes promoting harmful content, and that it denies victims an opportunity to seek redress when they can show those recommendations caused injuries or even death. And that's the publisher point that you're making this, argument about how they serve up things with their algorithms. They also put headlines on news stories. They decide which news stories to promote and which stories not to promote. That is a huge job. If people have ever worked in news, even if you haven't, one of the biggest things that people don't see behind the scenes is headline writing. It is a huge part of publishing. Story selection is a huge part of publishing. And from the perspective of journalists, these companies are doing all of that. They just don't have any of the liabilities that other journalists have, and they act like it's not journalism, so they don't take it seriously. They just serve up the dumbest stuff. And they
well, what they serve is whatever is going to keep you agitated and staring at their platform the longest, so that they can serve up the ads that are the real, core of the business model.
It's a slot machine.
It is. And so, I mean, if you think about it and you ask yourself, okay, should there be any limiting principle on Section 230? Imagine a theoretical platform where the recommendation algorithm is tuned so that the only stories that get amplified and recommended and served to people are left-wing stories. It's only about, whatever is going on. Everything that's on the right is sort of hidden. It's not banned or totally censored, although they could do that as well. And right now, the idea is it doesn't matter. You're still not a publisher. You still have no liability. Or imagine it the other direction, where your recommendation algorithm is designed so that it only pumps and promotes right-wing content about how great Trump is or whatever's going on there, right? Pizzagate or QAnon, whatever's hot at the moment. Can you really look at that with a straight face and say, oh, these are just, neutral common carrier platforms?
Right.
No, you can't. You can't. And so then the question becomes, okay, well, what is the limiting principle? What are the rules you have to follow? What is the business model that you have to engage in order to get the benefit of what is basically a giant gift and giveaway to these companies? So I think that most people would look at the situation and say, if you think about Fox News versus MSNBC. Part of the way that they present their very one-sided views of the world is through the type of commentators they have on, the opinions they express, et cetera. But a big part of how they do it is through story selection. That's like their own recommendation algorithm. What are they going to promote as like the biggest problems in the world? What are they just not going to talk about? On Fox, you're going to get a lot of stories about, there's a crime spike, there's an immigrant caravan, there's government spending gone wild, whatever. They're going to have their list. And if you're just consuming their content, the impression you're getting of the world is these are the core issues, these are the big things going on in society. If you're watching MSNBC, you're being presented a very different slate of issues to focus on as like the biggest threats to society, the most important issues ultimately in the world. That story selection is really, really critical to their propaganda efforts. And so we've basically said that social media companies can do the same thing. They can have these recommendation algorithms that are their own form of story selection that are dramatically, much more so than cable news at this point, shaping the way people perceive the world, and yet be totally held harmless for any harms that come to pass from those choices that they're ultimately making. And I think most people would look at that and say, that's ridiculous. Yes, in my opinion, there should be an availability of, Section 230 where you can avoid liability. I believe in free speech. I believe in people being able to post all kinds of content. But when you get into the manipulation of what gets seen and what doesn't, that's, I think, where you run into a problem where, okay, now you really are serving as a publisher and not just sort of a neutral platform.
Well, and they've also entered the fact-checking space. And that's hugely, hugely important. Again, it's another act of journalism, and they try to outsource it to journalistic outlets, nonsense fact-checking outlets that have so little credibility except for the fact that Facebook contracts with them or whatever, and that's their kind of fig leaf to get away with this. So they're absolutely acting as publishers. There's no question about it. This case is huge, especially because we also, as we mentioned, the Gonzalez family wants opportunities to seek redress. They're saying those opportunities don't exist properly because of Section 230. Tech has come to terms with the fact that maybe they should be lobbying for Section 230 reform because it hurts any potential competitors to the extent that it's even possible to compete with them way more. They can shape what the legislation would look like. They can lobby to make it friendly to them, and they can weather the regulatory burden way better than any potential new competitors can. So but you can't do that in the court. You can't shape the regulation that might come out of the Supreme Court. So just a fascinating, fascinating day, and a really important one for the future of the internet. And not one that I think many people are paying attention to, but it is unfolding today, Tuesday, here in Washington.
Yeah, absolutely. Hey guys, ready or not, 2024 is fully upon us now, and Saagar and I have been brainstorming ways that we can really up our game for this critical election.
Yeah, we rely on our premium subs to expand our coverage, to add staff, to upgrade the studio. We just want to give you the best independent coverage of this election, which is possible. So if you can help us out, become a premium subscriber today, breakingpoints.com, or the link is down here in the description video. It really means the world to us. And if you like what we're all about, this is the best possible way to keep us 100% independent, working only for you.